I'm back. The first recording I had to stop, let's say for technical reasons, but I didn't want to redo it, so that'll be part one. This is part two regarding the posting earlier about what happens in a personal injury case based on a vehicular accident. And I left off at the possibility that the claims would be settled without lawyers even becoming involved on behalf of the persons against whom the claims have been asserted. One point I would make is policy limits are going to be so important regarding the money available, not to be crass, but the money available to settle claims. And it makes a huge difference in a case where there's a serious physical injury that's substantial, is what I'm trying to say. If there's $100,000 on the table, or if it's a commercial liability policy, let's say, because a truck driver was involved in the accident, and there we're looking at coverage sometimes of over $1 million. And certainly the amount of coverage, if it's over $1 million, doesn't mean that a verdict or settlement in that amount will be reached, but it certainly creates a much higher ceiling and a lot more room for the attorney representing the injured party to work with. And then I have, if there's no settlement directly with the carrier, the lawyer will start a lawsuit against the person's claim to be responsible. And if you remember the earlier posting about liability insurance, the insurance company will hire a lawyer to represent the people against whom the claim has been made. And that lawyer will be representing those individuals, but it will be the insurance company who will arrange and pay for the representation. And by the way, just as the plaintiff's attorney, because now we have a lawsuit, is working on a fee arrangement of a contingent fee, a third of a recovery, the lawyers are representing the people against whom claims have been made, or the company against whom a claim has been made, and who are being paid by the insurance company are going to be working at a hourly rate. What'll be the hourly rate? That'll depend upon the market in large part. So we now have a lawsuit. Certainly in the evidence course and in the civil practice course, we talk about lawsuits and trials. But if we're just generally speaking about the lawsuit, how is it going to end? It could be dismissed. And what will happen in some cases certainly is the defense will feel it has very conclusive medical evidence that the plaintiff did not suffer a serious physical injury, and they may be able to persuade the judge there's no need for a trial because there's no evidence really to counter the conclusive evidence of no serious physical injury. That doesn't happen a lot, but it can happen. What is a likely outcome is that after the lawsuit begins at some point, it will be settled. I've had, as every other lawyer has had, cases settle right before trial and sometimes even during the course of a trial. If the case does go to trial, then a verdict is rendered. It may be rendered, we're going to have a jury trial in these cases. The verdict could come in, as we like to say, for the plaintiff, but sometimes it'll come in for the defendant. That is, the jury believes that there was no negligence on the part of the defendant, or possibly there wasn't a serious physical injury. When that happens, in other words, when the verdict is rendered for the defendant, sometimes you'll hear that referred to as a no cause. I'm jumping down to possible damages. What are the damages in a personal injury case? And now I can be speaking generally but obviously then that'll apply to a personal injury case based on a vehicular accident. We have a category of lost wages. Sometimes that's limited to past lost wages, but if an injury has impacted a person's ability to earn as much or earn at all in the future, we're talking about future lost wages. You know, at some point, again, if the lawyer has enough of a ceiling to work against, and we can bring in experts, we can, by way of example, bring in a vocational rehabilitation expert who will measure the plaintiff's future earning capacity and how that has been compromised perhaps by the injury suffered. We also have the same past and future for medical expenses. And again, just as we had a vocational rehab expert for lost wages, we can have a person, typically it can be the same person, who can forecast or predict what the future medical expenses may be based on the nature of the injury. In other words, we have certainly medical experts who will tell us what the injuries are and what the prognosis might be, but then we can have this person come in, this other expert come in and say, here will be the expenses going forward. Typically for the future lost wages and the future medical expenses, we can bring those down to present day dollars by using another expert known as a forensic economist. And then there's the category, we'll sort of end on this point, of pain and suffering as possible damages. And what is pain and suffering? Well, one thing we could say is it's a lot less quantitative than wages and medical expenses. Wages and medical expenses we can count. We can put specific numbers, dollars and cents. Pain and suffering is a lot more open-ended. And I think it's an area where the plaintiff's attorneys can be quite creative. Certainly there's physical pain and suffering. A person has an injury to the shoulder or back, and every time they move their body, it hurts. And it may well be that for the rest of their life, every time they move their body, it will hurt and perhaps even grow worse. There's also this idea of mental suffering. In other words, what enjoyments of a person's life are now compromised or, for that matter, lost because of the injury. I once had a client, and any lawyer could say this, by the way, but I once had a client, he was a real stoic kind of person. He goes, this doesn't hurt that much, even though his back had been terribly messed up. But as we were talking about how his life had changed, we came to the point where there was a recreational activity, was boating, that he really loved to do. He would fish, he would take his family out, he would hang out with his friends, and I think he also liked just going down to the marina by himself some days and hiding out. But he couldn't boat anymore. His back was too screwed up, and he gave it up, sold the boat. And at that point, this stoic guy about his pain actually began to cry. It was just he and I in the office. But bingo, there you go. That would be, I think, a real good example of pain and suffering in the form of mental pain or distress. I'm just going to say that once we get through with the trial, if we have one, or if there's a dismissal for that matter, there's certainly the possibility of an appeal. And again, that's something we can talk more about or have talked more about in the civil practice course. So there you have it. That's at least a little bit more of an explanation of this hand.